Welcome, everyone. Thank you for joining us for today's CITI program webinar. Today's topic is GDPR, Top Non-Compliance Risks and Mitigation Strategies, and is presented by Kristin Glenster. Just a few quick notes. This webinar will be recorded, and the recording will be available on the CITI program's website. This webinar is also for educational purposes only. It's not designed to provide legal advice or legal guidance. You should consult with your organization's attorneys if you have questions or concerns about the relevant laws and regulations that may be discussed in this webinar. In addition, the views expressed in the webinar are solely those of the presenter. Kristin Glenster is a legal expert who specializes in privacy, data protection, and emerging technologies and cybersecurity. She consults for the U.S. cybersecurity company Battleship Security on the GDPR and the ISO and SOC 2 standards. Kristin is a PhD candidate at the Faculty of Law and a member of the Center of Intellectual Property and Information Law and the Center for Science and Policy. She has studied at Harvard Law School and Columbia University and taught at the London School of Economics, Brown University, and Harvard University.
This webinar is designed to fulfill three learning objectives. First, we're going to review how the GDPR relates to higher ed and research activities. Second, from there, identify higher ed and research activities that may pose a risk to your compliance efforts. And then finally, identify and devise strategies for you to mitigate those risks as you move forward. This presentation or this webinar is constructed in three parts. There's a short review section to give you a introduction again to the most salient aspects of the GDPR when it comes to higher education activities and your research activities. And then we'll go into the non-compliance risks and then link them to the mitigating strategies that are most relevant to you, hopefully. So to go back to what the GDPR is all about, it's, as all of you or many of you will know, the General Data Protection Regulation that the EU adopted in 2018. It is what's called a lex generalis, which means that it is not sector specific. It covers. So does that mean differential privacy? Does it mean anonymization, whatever techniques you use, and that you don't share that beyond your research purposes? You can't do marketing on it, for example. So those are the areas that where the GDPR is most likely to come into play for you. So having said or given an overview again of the GDPR, let's take a look now at what I consider to be the most likely non-compliance risks. You are unlikely to be able to comply with the entire regulation just because it is contradictory and convoluted at times. So best effort here is probably good. And then your documentation strategy. Data flow tracking, protocols, training, and then contractual clauses for third parties. As I said, you are liable as your partners and other people, or not other people, other organizations, process your data, even if it's in-house, even if it's on your behalf. If they don't have a system that's compliant with the GDPR, you become liable. So my recommendation here is to make sure you have a commitment from your partners and your suppliers and whoever it is, that's contractual. That means that you can pass on any fine, any liability to them, should you be fined by national. So to summarize, we know GDPR is a complex, far-reaching regulation. You cannot do everything. But these are the things that the regulator is most likely to pay attention to for your kinds of activities. They're not going to care so much about your research data if it's properly anonymized and you're doing it for legitimate research purposes, unless there is a significant harm to the research subjects based on special category data. But if it isn't that, you're probably going to be fine. Certain activity in higher ed and research may be high risk exactly for that reason. Organizations can assess for potential high-risk activities. And again, the list isn't closed, so use your good judgment here. The list of special category data is a good starting point. Also, the more people affected, the higher the risk. There are many mitigation strategies that can be applied, as we saw, and you can do them in combination. They double up. There is not one size fits all. So I can't say, oh, just do these 4 things and you'll be fine. We just don't know, because it is technologically neutral. So the regulation doesn't specify enough for us to just say, oh, do this and you'll be fine. Use your common sense. What is important is that you don't let go of the data, that you are on top of what's happening at any time. The regulator is likely to look favorable if they can on your activities, if they can see that you've done a best effort, that it is proportionate, that you have thought about it, that you are not that you're not applying general policies or general purposes, or that you're lax with data minimization. If you can show that you've actually thought through how the data travels through your system, and that you've tried to mitigate any adverse use of that data to the data subjects, you are likely to be found to have complied as far as you can by the regulators. So those are my top mitigating strategies.
I also invite everyone today to review our content offerings regularly, as we are continually adding new courses and webinars in various areas of research, ethics, compliance, and professional development. You may be interested in our in-depth course on the GDPR entitled GDPR for Research in Higher Ed, or our course on tech ethics and regulations, which is continually updated with new modules to cover emerging topics. We also have an information privacy and security course that provides basic training on issues such as setting passwords, web browsers, and safely using devices. They're all a part of our continuing professional development content.